Mediation. What is it? What can I expect? And how can I prepare for it? One of the important things to understand about mediation is that it is entirely confidential. It takes place in front of a third-party neutral attorney, not a judge. It is not a time where evidence is presented. It is not a time where two different sides are presented and someone in the middle makes a decision. So the policy behind mediation being confidential is that parties should be able to negotiate freely without their potential offers that were rejected in mediation then used against them in court. The parties can agree in family court to things that maybe the judge wouldn't have the authority to order. There are some exceptions to the confidentiality, one being whatever is agreed to. Whatever is agreed to in mediation, the mediator then puts into writing in a mediation report and an agreement that everybody signs, and that gets filed with the court. Everything that is discussed in mediation that is not then put into writing in an agreement is confidential, cannot be used in court later, and the mediator is not allowed to share that information. There are other exceptions to the confidentiality related to the commission of a crime, child abuse, things like that. I'm not going to get into too much detail. That is something the mediator will explain at the beginning of the session. How does mediation work? So once you've completed your discovery in a family case, usually the attorney for the petitioner will file a motion to refer the case to mediation, and then the court will sign an order referring the case to mediation. That order then goes to the mediation department for mediation to be scheduled. If the parties' combined income is under $100,000 a year, the parties will qualify for court-certified mediation. The parties split the cost of mediation. Sometimes it's split based on their income. Sometimes it's split 50-50. So mediation can be on Zoom or it can be in person. The mediator will file what's called a notice of scheduled mediation, and that will have the date, the time, and the location, whether it's in person or on Zoom with the Zoom link. When you get to your mediation, the first thing that will happen is the mediator will give an overview of the confidentiality, what their role is, what the limitations of the confidentiality are, and kind of all the things to expect in mediation. After the mediator finishes their spiel, then the petitioner is the party that starts the negotiations. If I am representing the petitioner, I will usually prepare some kind of statement of the procedural history of the case, as well as the issues in the case and what each party is requesting based on the pleadings that have been filed. Then we will start with our first offer, and the mediator will get a response from the other side, whether they accept it or they're going to propose a counteroffer. And it just kind of goes back and forth like that until it's clear that maybe these issues are agreed upon and these are not, or we have a full agreement, or we're just really not going to reach an agreement. The mediator will draft a report that either has the contents of the agreement and what is left to be tried by the court, or that they reached an impasse, everybody showed up and no agreement was reached. If you are ordered to attend mediation and you do not show up, the mediator will put that in the report. Sometimes they will reschedule it once, depending on the circumstances, or sometimes they will say, one party showed up, the other party didn't, there was an impasse, and then you can move on with your case. Because mediation is generally a required step in all family law cases, even if you go to mediation and you reach an impasse, and it still got you a step closer to your final judgment, you can actually file a motion to dispense with mediation, to ask the court to skip it, not require it in your case. That's pretty difficult to get in my experience. The other thing I wanted to say is that usually mediation takes place all in one room. Everybody talks to each other in front of each other, but you can absolutely ask the mediator to be put in separate rooms. If it's in person, you would be in 2 physical rooms. If it's on Zoom, you can ask to be in a breakout room. And if you are in separate rooms, if there are things that were disclosed in front of the mediator but not the other party, that you don't want the other party to know, you can ask the mediator to keep certain things confidential and only authorize the mediator to disclose some information along with the offer to the other party. So how do you prepare for mediation? Sit down with the court docket and make a list of everything that's happened in the case so far. When was the petition filed? When was the other party served? When did they file a response? Are there any temporary orders? What's going on with the case? What has happened and where are we at this time? The other thing I will prepare are the issues. What is at issue in this case? Are there children? Is there property? Is there a claim for alimony? What are all the issues here? And then what is the position of each party based on the petition and the answer and counter petition filed if there was a counter petition? The last and most important thing that I do with my client to prepare for mediation is figure out our negotiating window. What is your best case scenario here? And what is the worst case scenario that you can live with and accept? That is usually a window. Even if it's a small window, it's still a window, and that's your negotiating window. You've identified your bottom line and your top line before you walk in there. You know that if they start making offers below your bottom line, we have reached an impasse. I think it gives you confidence and control in the situation. Good luck out there in your mediations.